Okay, good morning. Hello, welcome everybody to today's webinar on the Employment Rights Bill. I'm David Clay. I'm a legal director in the employment team at Field Seymour Parks. Just before we get going, just got a few housekeeping points to run through. So firstly, this webinar is obviously being held remotely, so please do bear with us should we experience any technical difficulties, and we'll look to resolve those as soon as possible. Webinar is going to be 45 minutes long today. All attendees are on mute. If you do have any questions as I'm going through, please put them in the questions box, which you should see to the right of your screen, and I'll endeavour to answer as many of them as I can at the end. Any I don't get to, we'll follow up on email afterwards. There will be a couple of polls during the webinar, so please do participate in those, bit of an interactive element. And finally, the webinar is being recorded and will be sent to all attendees later today. One final point I forgot to mention, there is going to be a survey pop up at the end of the webinar. So if you fill in your feedback there, you'll be entered into a draw to win a John Lewis voucher, which might come in handy in the run up to Christmas. Okay, so let's go to the next slide, the agenda. So in a brief moment, I'll give you a bit of background about the Employment Rights Bill. Then I'll take you through some of the key points in the legislation. So unfair dismissal, 0 hours contracts, flexible working, SSP, family-related leave, harassment, collective redundancies, fire and rehire, and a bit on unions. So as you can see, plenty to get through there. So apologies, it will be a little bit of a whistle-stop tour, but hopefully still some useful takeaways for you. Before finishing up, I will just have a look at timescales. So when can you expect the Employment Rights Bill provisions to come into force, and share a few of my own thoughts on the potential impact of the bill and steps that you might think about taking at this time to try and get a little bit ahead of the game in terms of your response to the publication of this bill. As I say, questions at the end. Hopefully I will manage to leave a bit of time for that. Okay, so on the next slide, a bit of background. So last week, I attended a lecture by the Employment Lawyers Association. It's a very interesting lecture if you find the Employment Rights Bill interesting. But they had a panel of different representatives. One of them was a lawyer from Unison, the union, and her opening remark about the Employment Rights Bill was that it was a ray of sunshine. So obviously very much welcomed by the unions. I'm not sure if employers necessarily see it in such a rosy light. But anyway, it's been coming. It's been on the horizon for some time. It's not a surprise. Labour made it quite clear that they were going to introduce some pretty bold reforms to employment rights through their plan to make work pay document, which they published in the run-up to the election, and they also said that they would be introducing draft legislation within the first 100 days of a new Labour government. I think in the end they published it on the Employment Rights Bill on about day 98 or so, so they stuck to their commitment. But I do think, you know, in making this commitment, which obviously, well, nobody forced them to do this, is very much self-imposed. You do, I think, to an extent, see the effect of that. It's very much a skeleton piece of legislation, the Employment Rights Bill, which is perhaps strange to say, seeing as it's 158 pages long and we've got 100 pages of explanatory notes, you know, other documents as well. But ultimately, what we've got with the bill is a framework, as I say, a skeleton which is going to be fleshed out in due course through secondary legislation, i.e. regulations. So yeah, while the bill obviously does give us plenty to get our teeth into at this stage, there is still a lot of detail which we're going to need to wait on and will only be clarified as and when regulations are published in due course. So at the moment, it's the Employment Rights Bill. It's going to be known as the Employment Rights Act 2025 when it becomes law. And just a quick note on territorial effect, the whole of the bill will be applicable in England and Wales, some elements not in Scotland and Northern Ireland, but I won't dwell on that, but just a point to be aware of. Okay, so in a moment I'll talk about unfair dismissal and what's changing there, but let's bring up our first poll just to check there's people out there listening. So in what year was the statutory right not to be unfairly dismissed first introduced in the UK? You've got 4 options there. So was it 1960, 1972, 1984, or 1996? I'll give you a few moments to make your selection on that. Let's see what we've got. Okay, so yeah, quite a spread there actually. So most popular one was 1996, followed by 1984. The correct answer here is actually 1972. So we've had a statutory right not to be unfairly dismissed in the UK for over 50 years now. If you put 96, you might be thinking of the Employment Rights Act 96, which is where the current provisions around the right not to be unfairly dismissed sit. So sort of understand that answer. But yeah, just 14% of you, 1972 is the right answer there. Okay, so let's have a look at the next slide. I think just next one on unfair dismissal. Here we go. So yeah, 50 plus years of a qualifying period of employment for ordinary unfair dismissal, but we are now going to have day one ordinary unfair dismissal rights for all employees. So that's really quite a seismic change, I would say, for employment law. But although we've got these day one ordinary unfair dismissal rights, there is still going to be scope to dismiss for capability, conduct, statutory restriction, or some other substantial reason relating to the employee during a statutory probationary period, also known as initial period of employment in the legislation, provided that you've gone through a lighter touch process. Now, you'll note in that list of potentially fair reasons, there isn't a reference to redundancy, and that means that a full redundancy process will need to be carried out for all employees moving forwards, regardless of length of service. Now, obviously, various points to be clarified here. So what is this lighter touch process that will need to be followed to dismiss during the statutory probationary period? Well, we're expecting regulations to provide some more colour on that, but I think it's likely that it could involve having given some sort of prior warning, or at least having met with the employee to discuss whatever the issue is, its performance conduct, potentially a right to be accompanied at that meeting, and I think likely that you'll need to produce some form of objective evidence to justify the reason for the dismissal. In terms of the length of the statutory probationary period, the government has said its preference is that it'll be 9 months. So that's not set in stone, but that's what they're looking at, which I think is a little longer than some people were anticipating. And also worth noting that the way in which the Employment Rights Bill has been drafted, the statutory probationary period rules are going to apply if the effective date of termination is within 3 months of the end of the statutory probationary period. So provided you've given notice to terminate at the end of the statutory probationary period, the rules around statutory probationary periods will still apply even if the EDT isn't until up to 3 months later. So that may remove some of the pressure that we currently have with the 2-year qualifying service threshold, where you're almost kind of compelled to pay in lieu as you get closer to that 2 years. With this new regime, it looks like there won't be perhaps quite the same pressure provided you've dismissed. By the end of the statutory probationary period, someone can remain employed for a short time afterwards. Different compensation regime. So this is quite interesting. The government's going to consult on whether there should be a different compensation regime where a dismissal takes place during the statutory probationary period. So I think the implication there is that perhaps the compensation available might not be as high as it is for unfair dismissal claims at the moment, but we'll have to wait and see. And then I've put there a different test for SOSRA or SOSR dismissals. So you'll see in the second bullet on the slide there, I've said that it's SOSR relating to the employee, which interestingly doesn't reflect the SOSRA test in the Employment Rights Act 96, which just talks about being able to dismiss fairly for some other substantial reason, justifying dismissal. So I wonder if we're going to end up with sort of two different SOSRA tests that we need to apply. One where the SOSRA relates to the employee during the statutory probationary period, and another where we're looking at it justifying dismissal once statutory probationary period is over. Finally, not something I've put as a bullet on the slide, but you might be wondering why is the government taken this route? Why are we going down this route with statutory probationary periods? Because they could have just quite easily relied on regulations to reduce the qualifying period, so perhaps say a 6 or 9 month period. They could have done that pretty much straight away without any lead-in period. And I think on that, there's probably a couple of reasons. Firstly, I think the government probably wants employers to have to do more to dismiss, regardless of the employee's length of service. And the statutory probationary period achieves that. And secondly, if they had just relied on the regulations to change the qualifying period of service, it would have then been quite easy if we get a Conservative government in the future for them to just flip it back again. Whereas introducing this new primary legislation is going to make it a lot more difficult to unwind these changes further down the line. So I think that may be what lies behind the reasoning for this new statutory probationary period approach. Okay, next slide is on 0 hours contracts. Now 0 hours is a term that's commonly bandied about, but just for clarity, this is a contract to do work which is conditional on the work being made available, but where there's no guarantee that that work will actually be made available. So initially the government was looking at banning 0 hours contracts or exploitative 0 hours contracts. It hasn't gone that far, but what we do have is a new requirement to offer a guaranteed hours contract to qualifying workers on 0 hours contracts or indeed low hours contracts. And that offer will need to reflect hours which are regularly worked across a reference period, which we think is very likely to be 12 weeks. Now, one point to note here is that this isn't just a one-time obligation to make the offer. It will be a rolling commitment. So at the end of every reference period, each 12-week period, you'll need to repeat that guaranteed hours offer if the individual still meets the test for qualifying workers. So in addition to the guaranteed hours contract offer, there's also going to be an obligation to give reasonable notice of and compensation for shift changes or cancellations at short notice. Now, the drafting of the 0 hours provisions in the Employment Rights Bill is very complicated, frankly, but notwithstanding that, there are still various points which need to be clarified, not least who is going to be a qualifying worker. So what are the relevant hours thresholds we're looking at here, I suppose, in respect of low hours contracts? What other conditions are going to apply? So that's still to be confirmed. The timing, form and content of the offer that's going to have to be made. Well, we know a little bit about the content of the offer. It's going to have to refer to the days or times of week when the work is to be carried out, or alternatively, the shift pattern that worker will be working under, but certain other details such as timing, form are still to be confirmed. Likewise, the length of time for the worker to consider and respond to that offer. Obviously, that's going to be a bit of a balance between giving workers flexibility to consider the offer versus businesses having certainty about whether that offer is going to be accepted and being able to plan for their resourcing needs moving forwards. Impact on seasonal working arrangements. This has already attracted a little bit of debate in Parliament. The potential issue that's been identified is if you've got somebody that you've brought in over a busy period, so obviously you're running up to Christmas, that would be an example. You've got 0 hours workers doing a high volume of work over a short period of time, which is not necessarily representative of what you may want them to be doing afterwards, but yet you've still got this obligation to offer a guaranteed hours contract based on the hours that were worked during a reference period. So we'll see what happens on that and whether there are any amendments to the bill as it goes through Parliament. What will constitute reasonable notice and what is the compensation sum? We know that the compensation, at least as the bill is currently drafted, won't be more than the amount payable for the shift where it's curtailed or cancelled, but otherwise further details still to be confirmed. And finally, how is all this going to apply to agency workers? Well, the government's consulting on that, and one of the key points they're looking at is, will the guaranteed hours offer have to be made by the agency that employs the worker, or will it have to be made by the hirer that the worker is actually performing their work for? So we await further information on that. Okay, so moving on to flexible working. I think some of the press headlines, if you've been picking up a paper or following the news on this, have perhaps been a little bit misleading because they're characterising flexible working as now being the default position. That's not quite the case. It's still going to remain a right to request flexible working rather than to an absolute right to have it. But it's, leaving that aside, it's certainly going to be harder to turn down flexible working requests in the future. So the current position is that you've got to follow a fair process, a reasonable process as an employer, and then cite one of the statutory reasons for turning down the request. And those 8 statutory reasons aren't changing, by the way. So, burden of additional costs, impact on quality, performance, etc. But the new position under the Employment Rights Bill is that the reliance on that statutory reason that you cite has got to be reasonable. So essentially, we're moving from what is very much a subjective test of the employer being able to cite a statutory reason to turn down the request to more of an objective test, where actually your reasoning, your rationale is going to be scrutinised a lot more by the tribunal. So that is a real shift in terms of how flexible working requests are going to be assessed by tribunals moving forward. There's no change to the max compensation that's payable for failure to comply with the law in this area. It's not especially high, it's 8 weeks pay, but that's subject to the statutory cap on a week's pay, currently £700. So I think I've done the maths right, 8 times 700 is 5,600. But of course, if you start getting multiple claims related to flexible working, then that all adds up. And in addition, when it comes to flexible working requests, it's not just this compensation. You've also got the risk of constructive unfair dismissal claims, discrimination claims as well. Points to be clarified. Well, what factors are going to be taken into account then in assessing reasonableness? I think we're going to look for some further guidance on that in due course. Okay, next slide, statutory sick pay. So what do we know on this? Well, the current system where you've got 3 waiting days and then you qualify for SSP on the 4th day is going to be abolished. It will be a day 1 right. And there's also going to be a new lower rate for low earners based on a percentage of average weekly earnings. So whereas you've got some people who currently don't qualify for SSP due to their low pay, in future they will be entitled to SSP, albeit at a lower rate. So you can have a 2-tier system there. But I think for the vast majority, the current system in terms of your flat rate of SSP isn't going to change. Now, the government has said that in its own impact assessment, this change is going to cost employers around £400 million a year. Obviously, big number, but I think the actual impact on your business is going to depend on what your current approach is on sick pay, because if you're already enhancing sick pay over SSP, well, actually, will these changes have that much of an effect? So there's a bit of analysis there to be done as to how it affects your business. In terms of points to be clarified, how will the percentage of average weekly earnings be calculated? We don't know. Frankly, I expect, given the sums of money that we're talking about here, it's probably going to be disproportionately complicated, but we await further details as to how to carry out those calculations. Okay, next slide is on family-related leave. So paternity, parental, and bereavement leave are all to become day one rights. So for paternity leave, that's a shift from 26 weeks at the moment. Parental leave, 1 year. Bereavement leave is already a day one right, but only for parental bereavement leave. So the position on parental bereavement leave is unchanged, 2 weeks paid at statutory rate, but eligibility for bereavement leave is to be broadened to a wider category of people. But for that wider category, it will just be 1 week of unpaid leave. There are no other changes to length of leave, whether leave is going to be paid or not, or the rates of payment. There has been some discussion in Parliament about whether paternity leave might be increased. People calling for that, mentioning perhaps a 6-week period of paternity leave. But as far as I'm aware, that's not going to change. That's not part of government policy. Points to be clarified. So which relationships with the deceased person will qualify for bereavement leave? You think it will be close family, cohabiting couples, etc. But I do wonder whether these bereavement leave changes are going to have that much impact in practice. I think most employers are already pretty supportive in these circumstances, and to the extent that they're not, then you're probably going to get signed off sick in these circumstances and at least get paid SSP rather than unpaid bereavement leave. Next slide then is on harassment. So this is a bit of a hot topic at the moment. Just last month, in fact, we had the new duty to take reasonable steps to prevent sexual harassment of employees coming into force. But under the Employment Rights Bill, the government is raising the bar for employers in this area, and the duty will now be to take all reasonable steps to prevent sexual harassment, including by third parties. And it's, as far as the third parties are concerned, the duty is to take all reasonable steps to prevent all forms of harassment by those third parties, not just sexual harassment. Sexual harassment is going to be a protected disclosure if it wasn't already, and disclosures about sexual harassment will be outside the scope of any settlement agreement confidentiality clauses. So what does reasonable steps to prevent sexual harassment mean in practice? Well, we already have some EHRC guidance on this. There's an 8-step guide, there's some technical guidance, there's non-statutory ACAS guidance as well, but I expect now there's going to be additional guidance given in regulations. Probably it's going to involve risk assessments, action plans, facilitating disclosures of harassment, and having a proper complaints handling process in place. And then the final point on the slide, will the Employment Rights Bill be amended to address the fact you've got this greater burden to prevent sexual harassment than other types of harassment? This is really just me speculating. I just wonder whether there might be some pressure from the MPs and the Lords to extend this all reasonable steps duty to other types of harassment, for instance, based on protected characteristics, but we shall see. Next slide then, collective redundancies. So this has not got as much press as some other changes, I think, but in my view, it's a really significant change. So as you may be aware, there is a duty to collectively consult employee representatives where you're proposing to dismiss 20 or more employees as redundant within a 90-day period. And currently, when you're looking at totting up the numbers, you're looking at each establishment, so each individual workplace essentially. But under the Employment Rights Bill, we're doing away with that, and instead you're going to have to look at numbers across the whole company. So if you're an employer with employees across multiple different sites, clearly the chances of the collective consultation obligations being triggered are now going to be far higher. To clarify, numbers are not at least going to be aggregated across an entire corporate group, so that's at least some comfort. But nonetheless, as I say, I think that's a significant change, and there'll be more collective consultation in the future. Some points to be clarified here. Well, the government is consulting on potentially doubling the protective award liability. So it's already 90 days pay, and that's gross pay, so actual pay. They're looking at doubling it to 180 days pay, so 6 months pay for breach of these obligations, or potentially even removing the cap altogether and leaving it up to the tribunal to decide what the protective award should be. So really hefty penalties potentially here. And they've also talked about extending interim relief to protective award claims as a disincentive to employers buying out rights. So at the moment, there's a tendency for employers to take a bit of an all or nothing approach when it comes to collective consultation. You decide, well, it's going to take so long and be so disruptive to go through this collective consultation. We'll just offer settlement agreements paying out what the protective awards would be. I think the government's really looking to make that option less attractive. In terms of interim relief, you may not be too aware of that. It essentially allows an employee to remain employed while their claim's going through the tribunal. It's very rarely used at the moment, only in certain types of automatic unfair dismissal claim, but government looking at extending its use to these scenarios as well. So points about multi-site employers that I've added at the bottom, these are just sort of my own thoughts. I just wonder whether, in light of these changes, we're going to see employers create standing bodies of employee reps to speed up the collective consultation process, rather than having to go through elections time after time whenever this crops up. I think that would be a consideration for some employers. And in addition, is there an opportunity to incorporate new legal entities for each of your sites? I think some employers do this already, but if numbers are not going to be aggregated across a corporate group and you've got a different legal entity for each site, might that help you to get around the impact of the new rules around looking at numbers across each company? Obviously, there could be trade-offs with that approach, that you may not want to do it because of additional admin and complexity that introduces to the corporate structures, but potential to take that approach, I think. Next slide then is on fire and rehire, or dismissal and re-engagement, as we probably refer to it as employment lawyers. I mean, fire and rehire, it's fairly emotive language, and the government really isn't fond of this. The next steps to making work pay document talks about abolishing the scourge of fire and rehire, so they really view it very negatively. But I think in reality, it's a pretty risky approach for employers to take. You run the risk of protective awards, which are potentially doubling or even going higher, multiple unfair dismissal claims from employees, potentially strike action as well. So it's not something that's done lightly by employers, but regardless, changes coming here, it's going to be much more difficult to dismiss and re-engage employees on new terms moving forwards, and dismissal for failure to agree new terms is going to be automatically unfair unless the business is at real risk of insolvency, basically on the verge of going under, and those changes are unavoidable. So that's a really high bar for employers to clear. And even if it's not automatically unfair, dismissal may still be unfair under ordinary unfair dismissal principles. So points to be clarified here. Well, I think one thing is, how is the tribunal actually going to assess the viability of an employer's business, and whether it would have become insolvent had those changes not been introduced? That's not really something the tribunal has a lot of experience at the moment, so that could be a bit of a challenge. And then consultation on extending interim relief to unfair dismissal claims in fire and rehire scenarios as well. Okay, let's move on to next slide on unions. So no surprise, I think, that the Employment Rights Bill has introduced various measures to strengthen the hand of unions. Workers will have to be given a written statement of their right to join a trade union on starting employment or engagement. Unions will have greater access to workplaces to recruit and organise, and that's not just where the union is already recognised by the employer, but even before a union has got recognition from the employer, that will apply. Just going to need a simple majority of those voting now for union recognition and strike action. So we're doing away with some of the thresholds we've got in place at the moment related to having to reach a certain threshold for turnout. Minimum notice of strike action is going to be reduced from 2 weeks to 1 week, or that is really just sort of reverting to the position pre-2017, and greater protection for detriment and dismissal due to taking industrial action. There's a consultation ongoing in this area covering various points, but including simplification of ballots. So looking at potentially introducing electronic ballots, rather than just paper ballots, and also what notice of strike action has to be given. So might it be reduced even to a shorter period than the 7 days? So next slide is a bit of a catch-all additional changes. If there wasn't enough already, here are some more things to think about. So employment tribunal time limits. You're probably aware the time limit for most claims at the moment is 3 months, technically 3 months less a day from the act complained of. But there are plans to amend the Employment Rights Bill so as to extend the limitation period for bringing claims to 6 months. Now, obviously, that's giving employees more time to bring a claim. It's a longer period of uncertainty. For employers, there's going to be a bigger gap between the incident giving rise to the claim and when that claim is actually going to be determined at a final hearing, which I think naturally is going to increase problems that we already see with delays in the tribunal, impacting on key witnesses having moved on, potentially memories of witnesses having faded because of that large gap. But nonetheless, we're expecting an amendment to the bill to deal with the extension of time limits. And then in addition, the government's going to establish a new Fair Work Agency. So that's going to be a single labour market enforcement body, initially with a focus on pay, including holiday pay, and outstanding awards owed. Now, it may be some time before this is fully operational, but interesting that the government's looking to focus on this and introduce this new single enforcement body. Other legislation, so the Employment Rights Bill is not the only piece of legislation or change we're going to see in the sphere of employment rights. Single worker status, the government's going to consult on this in due course, so watch your space on that. Unpaid internships, a call for evidence will be launched shortly. There are plans for a new statutory code of practice on the right to switch off, so when can employers contact their employees, and equal pay reporting. So for those employers with 250 plus employees, you'll be familiar with the gender pay reporting obligations, and this is going to be extended to cover race and disability pay as well. Okay, time for our second poll. So I mean, I'm going to tell you the answer in a minute, but just to see if you know already, when are the majority of changes in the Employment Rights Bill expected to come into force? So we're looking at January, April, October next year, or during 26. So give you a moment to have a think about that. Yeah, real spread. So 3% think it is coming in January, 34 April, 23 October, 40% during 26. Well, good news is that majority of these changes are not expected to come into force until 2026. So there is going to be a decent period of time to prepare. So if we move on to the next slide, how do we know that it's going to be 2026? Well, we've got this quote from the Next Steps document. So government saying we expect to begin consulting on these reforms in 25, seeking significant input from all stakeholders, and anticipate this meaning that the majority of reforms will take effect no earlier than 26. They add reforms of unfair dismissal will take effect no sooner than autumn 26. So particularly with the day one unfair dismissal changes, we're looking at nearly 2 years before that actually comes into effect. Now, of course, the government could change the goalposts here, but they've been pretty clear with that language, particularly on unfair dismissal. So I think it is unlikely that, at least with unfair dismissal, we'll see that brought forward. There will be some limited changes that come into effect when the bill receives royal assent and becomes an act, but I think they're probably likely to be limited to the union-related changes on the whole. So for most of these changes, there is a long lead-in time, unlikely that they'll be introduced before January 26. A couple of other points on this slide. So there are ongoing consultations at the moment, in particular on fire and rehire, collective redundancies, 0 hours, statutory sick pay, and unions, all with response deadlines in early December 24. Pretty short time frame the government's running these consultations for. I expect there are likely to be more in due course. There's also a committee stage, so the Commons has actually got its first meeting today to start looking at this, due to report by the 21st of January, and regulations and codes of practice, we're expecting those from next year onwards. Okay, next slide on my thoughts on the impact and the response. Now, by the government's own figures, they think this may cost employers up to $5 billion a year to comply with these new measures, although they do downplay that a bit by saying it's only 0.4% of the UK wage bill. But I think there's no doubt we're going to see an increase in employment tribunal claims. There's about 9 million people in the country currently with less than 2 years continuous service. So it's very hard to see a world in which we don't see more tribunal claims following the abolition of the qualifying period for unfair dismissal, and obviously the associated HR costs that come with that. Clearly, with day one unfair dismissal, there's going to need to be a greater focus on the recruitment process. I think also clearly greater administrative burden when using 0 or low hours workers moving forwards. These new rules on the guaranteed hours contract offers and notice and compensation for shift changes do look quite burdensome. And unfortunately, I expect we'll see more redundancies alongside a greater need to monitor numbers across multiple sites with the collective consultation changes. We've already had the CBI, the British Retail Consortium, making some public statements really about the impact of these changes, and of course not just the Employment Rights Bill, but on top of the changes on national minimum wage and employer national insurance contributions. There's quite a financial hit here, I think, for some employers. It will affect some more than others, but regrettably, I think we may see some more redundancies in due course. In terms of steps that that you can take, I think there's an element of financial planning here to work out the likely cost for your business. Audit of 0 hours arrangements is going to be important. Harassment training and communications should already be on the radar, really, with the recent legislation that came into effect last month. That's something we can certainly help with if you do need support on that in terms of audits, policies, training. So do get in touch if you want some help with meeting your obligations in that area. And then I think it's going to be worth a bit of thought about whether you might accelerate plans related to changes in terms, restructures, redundancies, because that is going to get harder from 2026. In due course, of course, there'll need to be some policy and procedure updates and management training. Okay, so next slide, I think just a little bit of time for questions. Let me see if I can open up the questions box. So we've got one here on contractual probationary periods and the extent to which they will still be you'll still be able to use them following introduction of statutory probationary period. I think you will still be able to use contractual probationary periods, but there have to be a little bit of a mindset shift in terms of it's not just going to be a case of you can automatically dismiss somebody during the probationary period without giving it much thought. With these new statutory probationary period changes, there'll be processes to follow. But I think contractual probationary periods might still have some value in terms of a performance management tool, particularly if you've got a situation where you are increasing the notice period that somebody gets once they've passed probation. But yeah, it will be interesting to see what approach employers take with contractual probationary periods following introduction of the new statutory probationary period. Let's have a look. Another question we've got is around inevitable increase in volume of tribunal claims. Is there going to be any additional funding for the tribunal system? There are, obviously already many delays. Yeah, I'm not aware that the government is planning to increase funding to the tribunal system. If they've been making announcements about that, I've not seen them. I think it would certainly need it. Potentially also some additional funding for ACAS as well. But yeah, I think it's quite likely that the tribunal system is already pretty stretched. Will it be able to cope with what looks like an increase in the volume of claims? We'll have to wait and see on that. Okay, I've got a couple more questions, but I've run out of time to get to those, so I'll follow up on email afterwards. Let's just close off then with the final slide. So obviously, I appreciate there's a lot to take in here. This has only been a high-level summary. We've got many details that are still to be confirmed in due course. It'd be great to see you at one of our next events, but both of these in-person events. So we've got our Christmas HR Networking Forum on Tuesday, the 3rd December, so next Tuesday at Carluccio's in Reading. We've had great feedback on our HR forums recently. It's a really good opportunity to meet other people who are potentially going through the same issues as this year at the moment. So be great to see you at that. And then in the new year, towards the end of January, we've got our annual employment law breakfast briefing. My colleague Ian McRae, one of the partners in the team, will be delivering that one at the Green Park Conference Centre in Reading. So that takes us to the end of the webinar. Please do complete the survey when it pops up in a moment. But thank you very much for attending. I hope you've found it helpful and informative, and enjoy the rest of your day.